Asterisk as Jasmine Crockett stepped up to the podium, the Supreme Court chamber went completely still, her sharp navy suit cutting a striking figure against the rich mahogany panels. The camera closed in on her calm, self-assured smile, a quiet island in a sea of tension. Just moments before, Justice Stephen Breyer had shocked everyone by cutting off opposing counsel mid-sentence with a statement no one saw coming. Asterisk, I want to hear what Representative Crockett has to say. The legal analysis in her brief was outstanding. The conservative justices shifted in their seats. Chief Justice Roberts lifted an eyebrow. Then, as Crockett opened her folder, Breyer leaned forward and spoke words that would echo through the legal world. Asterisk, Congresswoman, your constitutional argument challenges decades of precedent in ways I find impossible to ignore. Please walk my colleagues through it. Whispers swept the gallery until the marshals restored order. Crockett stood steady, ready to deliver the argument that would silence her doubters and forever change how the Supreme Court saw this rising star from Texas. Asterisk, before we go any further into this historic moment, make sure you like and subscribe for the sharpest political analysis and Supreme Court coverage. Representative Jasmine Crockett was no stranger to high-pressure courtrooms. Long before Congress, she had built a fearsome reputation as a civil rights attorney in Texas, taking on cases everyone else called impossible. Asterisk, her rapid ascent from the Texas House to the U.S. Congress had been powered by viral moments of razor-sharp questioning and her gift for making complicated law crystal clear to everyday Americans. But nothing had prepared the country for what was about to happen today. The case was about voting restrictions that hit minority communities hardest, the very fight Crockett had dedicated her career to. Asterisk, for weeks, conservative pundits had sneered that she was out of her depth. A freshman congresswoman playing dress-up lawyer at the Supreme Court, one host scoffed. Breyer's going to dismantle her. Justice Stephen Breyer, in his final term before retirement, had spent decades as the court's pragmatic liberal, obsessed with how laws actually work in the real world. Asterisk, famous for deep philosophical questions and unrelenting intellectual rigor, he had shaped American law for generations. But that morning something felt different. He was studying her. NPR's Nina Totenberg later said his copy of Crockett's brief was dog-eared, highlighted, and covered in his handwriting. Asterisk, almost no one knew Crockett had spent months developing a brand new legal theory that challenged recent voting rights decisions without directly attacking the conservative justices who wrote them. She drew from forgotten Reconstruction-era principles and original historical sources, an argument both bold and meticulously rooted. The stakes could not have been higher. Millions of voters' access to the ballot was on the line. Asterisk, a loss would lock in restrictive laws for years to come. Conservative legal organizations flooded the court with amicus briefs calling her ideas radical and dangerous. As Crockett organized her notes, Justice Alito leaned over to Justice Thomas and whispered something that made them both smirk. Justice Barrett tapped her pen. Only Breyer kept his eyes locked on Crockett, as if he alone saw what everyone else had missed. Asterisk, Congresswoman Crockett, Chief Justice Roberts began, you have 30 minutes for your argument. I remind the court has recently addressed these very issues. The precedent is clear. Crockett nodded respectfully. Thank you, Mr. Chief Justice. I am fully aware of the court's precedent. That is exactly why I am here today. Asterisk, the stage was set for a showdown the marble halls had rarely seen. Crockett began in a calm, measured tone, nothing like the fire she shows in congressional hearings. Justices, I draw your attention to Section 2 of the Voting Rights Act, which this court has interpreted to require proof of discriminatory intent rather than mere discriminatory effect. Asterisk, Justice Alito jumped in almost immediately. Congresswoman, that is settled law from just 2 terms ago. Are you asking us to overrule our own precedent? The condescension was unmistakable. Crockett never blinked. No, Justice Alito. I am asking the court to apply it correctly. She placed a new document on the lectern, one that had not been in the original briefs. Asterisk, this statistical analysis did not exist when that case was decided. It shows that, even under the court's own intent standard, the pattern is explainable only by race. The room tightened. Challenging Alito head-on was audacious. Then Justice Thomas spoke, a rarity in itself. Congresswoman, statistics can be interpreted many ways. Why is yours the right one? Asterisk, before she could answer, Breyer cut in. Actually, Justice Thomas, the methodology tracks exactly what this court approved in Johnson v. United States in 1987. It is sound. He turned to Crockett. Please continue, Congresswoman. Reporters scribbled furiously. A liberal justice was shielding her from the conservative flank. Something monumental was happening. Crockett kept building, brick by brick, citing obscure precedents that forced justices to flip through their binders. When Justice Barrett pushed back on a 1980s case, Crockett quoted Barrett's own Law Review article from her Notre Dame days, an article that actually supported Crockett's position. Silence fell. Even her harshest critics had to admit, Jasmine Crockett had come breathtakingly prepared. Justice Barrett, I believe you wrote in 2016 that statistical disparities of this magnitude create a presumption that shifts the burden to the state to prove no discriminatory intent existed. I am merely applying your own scholarly framework to these facts. Barrett looked stunned that her past words had come back to haunt, or help, her. The pressure kept rising as Crockett calmly dismantled every conservative counterargument with surgical precision instead of theatrics. Justice Kavanaugh tried a different angle. Congresswoman, even accepting your statistics, doesn't the state have a compelling interest in preventing voter fraud? These laws seem narrowly tailored to that goal. It was a trap designed to make her sound soft on election integrity. Crockett smiled slightly. Justice Kavanaugh, I'm glad you asked. She slid forward another document. I have reviewed every voter fraud prosecution in the state for the last 20 years. There were exactly 13 cases, and none would have been prevented by these restrictions. Yet these laws would disenfranchise an estimated 740,000 eligible voters. If we are talking narrow tailoring, this is the opposite. Breyer gave a small nod. The conservative justices exchanged uneasy glances. As her time wound down, Chief Justice Roberts finally spoke again. Congresswoman, your statistical evidence is compelling, but this court has been reluctant to second-guess state election laws absent a clear constitutional violation. Crockett had been waiting for that opening. Chief Justice, that is why I saved my strongest argument for last. She opened her briefcase and produced a thick, leather-bound volume none of the justices had ever seen. This is a newly authenticated transcript of the congressional debates during the drafting of the 15th Amendment, statements from the framers themselves addressing exactly the kind of state actions we see today. The justices visibly leaned in. Newly discovered, authenticated Reconstruction-era records are legal gold. I have had this document verified by historians at 3 separate universities, she continued. It shows the framers specifically intended to reach facially neutral barriers that disproportionately burden newly freed black citizens, even when race was never mentioned in the law. Justice Breyer immediately asked, "May I examine that document, Congresswoman?" She nodded, and the clerk carried it up. You could feel the air change. Crockett had saved the kill shot for the final seconds. As the red light flashed, time expired, she closed. These records supply the clear constitutional violation the Chief Justice sought. The framers saw this exact scenario and acted to stop it. Normally Roberts would simply thank counsel and move on. Instead, Breyer spoke first. Mr. Chief Justice, I believe the court would benefit from giving the Congresswoman additional time to elaborate on this extraordinary historical evidence. Gasps rippled through the press rows. Roberts paused, then said, 5 additional minutes, Congresswoman. Please be precise in connecting this document to our modern doctrine. Legal reporters in the room knew they were watching history. The tone had completely flipped. The Congresswoman once mocked as inexperienced now commanded the nation's highest court, with one of its legends openly championing her reasoning. Crockett used every second of the extra time masterfully. She walked them page by page through quotes from Charles Sumner, Thaddeus Stevens, and Jacob Howard showing the framers deliberately crafted the 15th Amendment to catch indirect and procedural evasion tactics. When Justice Thomas pressed again on disparate impact, she replied, Justice Thomas, that is exactly why these records matter. The framers rejected a pure intent-only test. They built in a burden-shifting mechanism once severe statistical disparities appeared. Breyer's eyes lit up, he had found the exact passage himself. Barrett asked whether this meant abandoning 150 years of precedent. Crockett answered smoothly, not at all, Justice Barrett. It means returning to the Constitution's actual meaning, which would actually make our voting rights jurisprudence more coherent, not less. Asterisk she closed with a chart showing her proposed standard would affect only the most egregious laws, leaving most election regulations untouched. When the gavel finally fell, Chief Justice Roberts's tone had softened noticeably. The court thanks you for an exceptionally thorough presentation, Congresswoman. Asterisk Crockett returned to her table. The opposing counsel looked shell-shocked. Reporters bolted for the doors. Headlines wrote themselves, Breyer stuns court, embraces Crockett's originalist voting rights revolution. Asterisk 3 days later the court issued an almost unheard-of order, supplemental briefing requested on the historical evidence Crockett introduced. Legal scholars called it a five-alarm signal that the justices were seriously rethinking the case. Inside the conference room, sources say Breyer was uncharacteristically forceful, telling colleagues that ignoring the new evidence would be intellectual dishonesty of the highest order. Asterisk back on Capitol Hill, Crockett's office was swamped. CNN, MSNBC, and even Fox were begging for interviews. Hashtag Jasmine Crockett trended nationwide. She told the cameras outside her office, I just presented the law and the facts. The Constitution doesn't belong to one party. It belongs to the American people. Asterisk conservative commentators tried to wave it away as theater, but serious legal voices on the right were impressed. Originalist scholar Randy Barnett tweeted that the newly surfaced debates were potentially game-changing. 2 weeks later Breyer gave a speech at Yale in which, without naming the case, he spoke of moments when new evidence demands we re-examine whether our precedents have drifted from the Constitution's true meaning. Asterisk 45 days after argument, the court announced the decision would drop the following Monday, an unusually long delay that suggested shifting votes and complicated opinions being negotiated. The night before, Crockett told 60 Minutes, whatever happens tomorrow, we have already changed the conversation. This is about whether millions of Americans get to vote. Asterisk Monday morning, the courthouse steps were packed. At 10 a.m. sharp, Chief Justice Roberts began, the judgment of the lower court is reversed, 6-3. Shock waves rolled through the room. Crockett had not only won, she had flipped at least one conservative vote. Asterisk Roberts laid out a new framework, severe statistical disparate impact on minority voters triggers a burden shift to the state to prove a compelling, narrowly tailored justification, a standard he said was faithful both to precedent and to the original understanding of the 15th Amendment as illuminated by Congresswoman Crockett's extraordinary historical submission. Asterisk Justice Breyer read a concurrence from the bench, a rare honor. Representative Crockett's historical research and constitutional reasoning remind us that fidelity to the Constitution is not owned by any one judicial philosophy. Justice Barrett wrote a separate concurrence joined by Justice Kavanaugh, calling the new standard workable and balanced. Asterisk Alito dissented, joined by Thomas and Gorsuch, calling it an unwarranted departure. But the headline everywhere was the same, Jasmine Crockett had just rewritten voting rights law. Asterisk that afternoon President Biden called personally to congratulate her. Civil rights leaders called it the most important voting rights victory in decades. When Crockett stepped outside the court, the crowd roared. She raised both hands and said, "Today the Supreme Court reaffirmed what should never have been questioned, the Constitution protects every American's vote, no matter their race or zip code." Asterisk later that evening she found a handwritten note on her desk in Justice Breyer's unmistakable script, "In 30 years on this court I have rarely seen advocacy that so perfectly wove history, principle, and practical wisdom. You have changed the trajectory of voting rights law for generations. With deepest respect, Stephen Breyer." Asterisk she folded it carefully, slipped it into her drawer, looked at her staff and said, "We won a battle. The war continues. Back to work." Asterisk in the months that followed, states rushed to comply. Law reviews dissected the new standard. Con law professors built entire courses around Crockett's argument. She began teaching master classes at Harvard, Yale, and Stanford. And when Justice Breyer retired the next year, he called her appearance one of the defining moments of my career. Asterisk the story of how a freshman congresswoman from Texas walked into the Supreme Court, earned the respect of Justice Stephen Breyer, and bent constitutional history toward justice will be told for generations. Asterisk thank you for watching this incredible story of courage, brilliance, and the power of one voice to change the Constitution's future. Like, subscribe, hit the bell, we'll keep bringing you the stories of people defending America's most fundamental rights.